Maria, kom maar laat witness, Kim Martin.
Michelle Martin.
Do you have any objection against taking the oath?
No, I don't.
Do you swear that the evidence you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Raise your right hand and say, so help me God.
So help me God.
Thank you. You may be seated if you so wish.
Thank you.
Madam, you've given evidence in the court before during the trial we had in this matter. Is that correct?
Yes, I have, my lady.
And you can still remember your evidence?
Yes, I do.
You confirm the contents of the evidence you gave?
Yes, I do.
Now, Madam, it's now a year and more later. Do you still think of Reba?
Every single day. Not a day goes by without thinking about her.
How are you coping?
My lady, coping, yes, because you've got to get on with your life. But the scars, the effect runs very, very deep. We'll never completely get over it. But I'm a mother of 3 children. I have to cope. I have to be an example for them. I have to give them hope for the future. They're at an age where they need to be able to make sense of what has happened. So I have to be strong for them. So coping, because we have to, yes. But getting over it, no.
And your children, are they coping?
I try, as a mother, do the best job that I can. They are young and find it very hard to process what has happened. It's been 3 years now since the incident, my lady. And at different stages, I see different effects coming through on my children. I don't want to, for sensitivity reasons, explain exactly what my children have been through, as I did previously, because I've seen the effects on them, but they suffer very much because of this.
Has it changed your life?
Yes, it's changed my life completely. Besides the obvious anxiety and depression, as a family, we'll never ever be able to carry on like normal. You know, just standing in the queue at a shopping centre poses difficulty. You know, people don't recognize you and they start mentioning the trial, or they start mentioning Oscar, or they start mentioning Reva. And you can never be prepared for what might come up. You know, I attended a workshop a couple of weeks ago, a self-awareness workshop. And without the people realizing, the lecturer started speaking about Oscar and his gun complex. And I just went cold. You know, it's never going to leave us.
You, apart from you, your children, the broader family, how are they coping?
My dad, for instance, I saw my dad cry for the very first time when Reva died, and I saw him cry for the very second time when he heard that I had to testify again. It's very unfair what our family's been put through. You know, losing a family member that was such a big part of our lives in the way that we did, and then to have to be exposed to the media, to have to sometimes defend ourselves, it's very difficult.
Talking about media, do you know anything of an interview that the accused gave to the media?
The only thing that I do know is what I've heard on the radio and TV, that he's going to be doing, what he's done an interview, and that it's going to be viewed on the 24th of June.
And how do you feel about that?
I'm not happy about that at all. I just think it's very unfair to want to talk to the world about your version when you had the opportunity in court to do so. And it's just, it's hurtful. I just don't understand why. I can't understand why.
So, as a family, you have Christmases and birthdays. How does that affect the family of Rivas?
It's terrible because we want to be there for each other. We want to be able to celebrate. And for me, for my children, I can't let every special occasion be about Riva being murdered, about not saying anything. We have to celebrate. We have for them, you know, my youngest daughter is 17 years old. She doesn't deserve to have every special occasion cut short. As it is, Valentine's Day is the worst day for us. Christmas, we all want to be together, but we're also scared to mention something. We're going to set somebody off. We want to honor Riva's memory by leaving seating, like we said, by putting the candle out for her. But we don't want every occasion to become a funeral, you know?
And your Uncle Barry, how's he coping?
As far as I'm concerned, my uncle is a broken man. You know, he lives day to day on his phone, just watching the posts about Riva. The guilt, the father not being able to protect his daughter. It's very difficult for him.
You've said during consultations that you expected something of the accused from the start. What was that?
I didn't hear your question.
You explained that you expected something from the accused from the start of the trial. What was that?
And my lady, all we've ever wanted is the truth. And I know people said, but you got the truth, but we didn't. Oscar's version changed so many times. And I never ever heard him saying that I apologize for shooting and murdering Riva behind that door. I don't feel there was an apology from him. I don't feel the true version came out. We just wanted the truth. That's what we wanted.
Thank you, lady. Nothing further.
Yes, Mr. Van.
Thank you, my lady. Ms. Martin, I was very, very careful when Mr. Steenkamp gave evidence because I understand the pain. But there comes a point that I have to draw a line. And where we also must focus on what's going on with the accused in this matter. And I've unfortunately reached that point. I'm going to read to you some transcripts and some interviews, including one of yours.
Okay, may I sit down?
Yes, of course.
Thank you. And
I will demonstrate and later argue to the court how everyone either did not know what was going on in the relationship or experience his relationship with the deceased as a good relationship. But then, after hearing rejected evidence in this court and media publications about rejected evidence, then suddenly he became the villain. And I'm going to take you through it. What was before this court in the bail application, and I just want to deal with the relationship between the accused and Riva, the deceased, and how it was experienced by a close friends. Samantha Gravenstein, that was undoubtedly a closest friend, described this in a statement that's part of the record. After saying that Riva was her best friend, paragraph 7. After a while, Riva and Oscar started dating. Riva told me that Oscar was amazing and he treated her like gold, and that she thought they had a lot in common. Riva told me she really liked Oscar. The relationship slowly progressed and became more serious. Riva often mentioned how happy she was and that Oscar made her feel that way. And I want to read the second part to you, and then I will go also to what Gina Myers, another best friend, was saying. Paragraph 9. Riva confided in me that even though she and Oscar had not been together for very long, she really loved Oscar and she could see a future with him. She told me that if Oscar asked her to marry him, she would probably say yes.
Sorry, my lady, was this still Sam Gravenstein saying
That's
this?
right.
Okay.
Do you have any comment?
Yes, first I'd like to say that I didn't even know Sam Gravenstein, so she might have been quite close to Riva at the time, but I didn't know that she was even a friend of Riva's. And I asked Riva, and I was very close to Riva. Riva and I were like sisters. I asked her, "Are you happy?" And she said to me, after shrugging her shoulders, she smiled and she went, "We will speak later." I could see she was bubbly. I could see she was excited. And I could see there was a fondness for Oscar, but I did not see any love. So Riva had opportunity to tell me that she loved Oscar, and she never did. We spoke over WhatsApp.
Is that as far as Riva went in discussing Oscar with you, to shrug her shoulders?
When I asked her, when I questioned her feelings for Oscar,
Yes.
and I questioned her happiness, that's as far as she went, yes.
And that's where it stopped.
Yes.
We'll get back to it.
Okay.
And we'll get back to an interview that you gave
Okay.
and your previous evidence. And then you will see why I said in the beginning that I'm sort of concerned. Another friend also wanted to be described as a best friend was Gina Myers. You know her?
Very well. As far as I'm concerned, she was Riva's best friend.
Yes. There are two interviews, live interviews. The one was with Mandy Wiener on 27 February 2013, so shortly after the event. And I'm going to read the question to you, and I think you can accept what I say, otherwise we'll play it. And how did she feel about the new relationship? I can tell you that was a reference to Mr. Pistorius. Answer. She was happy. I think in every relationship there's ups and downs, and you know stuff that you go through when it is a new relationship. But everything was normal. Let me read the second one.
Who was she interviewing? Sorry.
She gave an interview to Mandy Wiener.
No, who was?
Gina Myers.
Okay.
You want to comment on that or wait for the second one?
No, wait. Thank you.
The second one was with Andrew Harding of BBC. Same date, 27 February 2013. Question. Do you think Riva was happy? Answer. I did. And in a relationship? Yes. Any comment? You don't have to comment. I ask if you have any comment.
Yes, I know. Thank you. I can't speak for Gina, my lady. I've heard lots of things about how Reva felt about Oscar. I don't really know what the point is. I mean, yes, I know she liked Oscar. I don't think she loved him. I think she was very fond of him. I think she had a very soft spot for him. I can't comment on, I don't understand what you want me to comment on
No,
their feelings.
It's just a decent thing to do.
Okay.
Now, you said previously in your evidence that when you asked her about the relationship, she really didn't tell you, she shrugged her shoulders. And you talk later, but that occasion never occurred.
Correct.
Is that correct?
Correct.
So you don't really know what was in the relationship?
Correct.
Yeah. Can I remind you what your previous evidence was? And it concerns me, because the court must work on this. At page 3647, and then I will go to an interview that you had with Pierce. You were asked about it. You explained at the bottom of 3647. You explained that when Riva was an adult, she was living in Johannesburg. She confided in me what that relationship, what it was about, and what it had done to her, and how it affected her, and to what extent it was, how abusive it actually was. That was your previous evidence, and we know now you could not say that.
What relationship are you speaking about?
I object, yes, my lady. We should make sure that we're talking about the relationship with Oscar, because it's not.
Well,
That's not. I never said that about her relationship with Oscar. I said that about her previous, one of her very first relationships.
well, if you're right, then I will apologize, because I'm reading it here. You say, do you say that it had nothing to do with Oscar?
That had nothing to do with
Then I
Oscar.
apologize. Then it's wrong. My understanding then is, and I really apologize, then it's a wrong reference to you. Let's go to the interview. Can you remember that you had an interview? It was aired 20 February 2013, shortly
remember
after the event.
Very clearly, yes.
And you were asked about this, and you said the following: would this be correct? When did Riva tell you that she was dating Oscar Pistorius? Can you remember that?
I'll get
That was the
there.
question, yeah.
Yes.
You don't have.
Okay.
And you answer, well, I saw it in the news first, and that was about only 2 months ago. When it first came out, there was rumors. When she attended one function with him, and I remember I sent her a message, and I said, is it true, cuz? And at the time she said no, but he's a very nice guy. And that's basically it. She never really spoke much to me about him other than that. Would that be correct?
That's correct.
So all that you really know is that she described him as a nice guy. And that's as far as it went.
Correct.
You know about the Valentine's card that she made for him saying, I love you?
Other than hearing about it in court, no.
I have no further questions, thank you.
No re-examination.
Thank you very much, Mrs. Smart, for your assistance. You may be excused.
Thank you.
That concludes the evidence for the statement.
Thank you very much. Yes, Mr. Roux,
I'm so sorry.
do you want to call any more witnesses?
No, my lady.
You don't. Are you ready to argue?
We're ready, my lady. May I just, 1 minute just to get copies of the heads of argument? I just hand to you a copy of our head's argument? And what I've done, I've prepared a separate bundle for the annexures there, too, otherwise it's too voluminous and it's difficult to deal with. I will also, at the right time, it's just because I don't have it in my hand, give you the copies of the cases that we referred to, just as a matter of convenience, my lady. Here it is.
Yes, Mr.
My lady, just to explain to you the format of our heads of argument, we took your judgment and then compared it to the judgment of the Supreme Court of Appeal to see what is different. And then at the end you will see we come to what we call the distilled facts, meaning what facts remain undisturbed and what is new and what is that complete picture, in order to try and present to you a complete picture based on a reconciliation between the two judgments, because it was not too difficult to reconcile them, as you will soon see. But before I deal with it, if I may say this, my lady, there are serious enemies, so to speak, in this matter. And the first one is that there was a perception created that the deceased wanted to kill the deceased. That direct intent theory. And it does not go away, because once you have created a perception, some people who wish to be informed and who wish to sit back and analyze the facts and put their trust in the court would then consider, was it really true that he wanted to kill her, that Dole's directors? Or is the finding very different because we know now the objective evidence, and I'll get back to that. And is it not perhaps a different picture? And to what extent has that different picture changed? It doesn't happen in this case. Sometimes understandably so, sometimes not. Understandably so when you have a father that's hurting, and what's in his mind, because what was put in his mind is there, and it's not for me to cross-examine him on the court's findings. You can only have empathy and sympathy with the parents. But the unfortunate part is that hurt, that pain is aggravated by perceptions created in this trial. That's the unfortunate part. The second one is, the second enemy in this trial is, there is from some part of the society an unwillingness or an inability, I don't know which one, to see this accused in the context of that evening. He's still portrayed in their minds and somewhere in the media as this person winning gold medals, the strong, ambitious person, 1.84 meters. And that would have the effect that the real facts become concealed. That takes away the real context, where it was not the man winning gold medals that must be judged. It is common cause. It was a 1.5 meter person standing on his stumps, 3 o'clock in the morning when it was dark. And once you start and want to see it, of course a very different picture would unfold. But if there's resistance to accept that, then of course it would so perfectly attach to the I wanted to kill the deceased theory. The third one is, once you have bad emotions about the case, like the emotions, the negative emotions caused by the first two perceptions, then many people have either an unwillingness or an inability to set the bad emotions aside and to look at the true facts and to say, but what really happened? Instead of saying, I don't believe it. I don't believe it means I don't believe times on cell phones. I don't believe other objective evidence that I will come to. Not things that people thought, objective evidence, we've dealt with it in a timeline. I distinctly remember this court asking the state, can you deny that? There could not be a denial. They were objective grounds. But if you allow perceptions to control your thought process, you would not even pay any attention to objective facts, to objective impossibilities. And that's the difficulty in this case. Those factors, and whatever sentence you impose, there will always be a group of people refusing to allow the true facts as found by the court, and for this instance the courts, to rather prescribe to them and to their emotions what an appropriate sentence should be. There can never be an appropriate sentence if you believe that he had an argument, he wanted to kill her and she ran to the toilet and he killed her, which are not the facts. Not because we don't think that they are the facts, because those facts were absolutely refuted by objective facts, not by say-sos. But I understand it in some instances when you go through pain. I understand it. I don't always understand it for people more removed, why they don't want to sit back and look at the true facts. The fourth one, the fourth enemy is, and I've unfortunately seen this in different contexts, is that we have a concept in the criminal law that we call benefit after doubt. But what we then see when it comes to whether to convict or not, that the court very correctly, because the court is trained in that process and experienced in that process, say, well, you may have done it or you may not have done it, and it's not as fanciful possibility. I have a reasonable doubt, not a fanciful doubt, not just a distant possibility. I have a reasonable doubt that you didn't do it. But then when we get to sentencing, there's sometimes, and very much also in the minds of lay people, this perception that, but hang on, maybe he did it. And then you can't just sentence him because you have doubt. Maybe you must include a couple of years for that possibility, for that doubt. So the doubt becomes then the aggravating factor. Without saying to yourself, but hang on, how can I add years? How can I ask for a more severe sentence? If the reasonable possibility at the very least, if not the probability, is that he didn't do it. How can you add years? How can you now say, well, maybe he did do it and I'm going to punish, or I want him to be punished more severe. Those factors, those four enemies, remain in this case. Whatever I'm going to submit to this court, whatever I'm going to say about your judgment and the Supreme Court of Appeal judgment, they will never disappear unless, not this court, society, unless the members are prepared to say, should I not just sit back and think for one moment that there might be another version and it might be true, and what then? What if it is so? What would I want then to happen to this man? And the brilliant example that we have, most of us remember that very, very tragic incident of Vleis Versace, a well-known rugby player, where he saw sometime late night his car driving out, living on a plot. And he thought someone was stealing the car, and he fired a shot, and it was his daughter, and it killed her. It was not right to fire the shot. Of course not. And if you analyze it in view of the Supreme Court of Appeal judgment, when he at the very least foresaw and reconciled with the possibility that he could kill that person, it's murder dolus eventualis. But everyone sympathized with him because they understood, and he was not prosecuted, if I may add. He was not prosecuted. There's a statement by the prosecuting authorities to say, it's not right to prosecute him, it's inappropriate, and I agree. But that's not the point that I'm making. I'm not asking for a non-prosecution. But everyone understood that you can make a mistake where you shoot at a person under a mistaken belief, and that you're law then guilty because you still shot at a person. But then there comes this little tail back to it, and it's again converted into he wanted to kill the deceased. Everyone in the Vleis Versace understood, and when you ask everyone, they would say, it's terrible. It's of course terrible. I think so often about him. How must you feel when you know you should not have fired that shot at your own daughter? But maybe not exactly the same class. But how must you feel when you fire those shots that you should not have, and it's your own girlfriend? But that privilege, that thought process, in some instances, remain absent. And what do? We criticize without sitting back and following the process. And that is what we try to do in the heads of argument, my lady, where we say, you have a number of questions to answer. The first is, of course, that the prescribed sentence, the discretionary sentence, as they call it nowadays, that it is 15 years for murder, unless, of course, you find substantial and compelling circumstances. And we will take you through the heads of argument to explain why we say there should not even be an argument that those substantial and compelling circumstances are present in this case that would allow you to deviate from the discretionary sentence. We say to you, and we refer, and that's page 3 of our heads, my lady, we refer you to the Malgas case, and then a very, very useful application of the principles in Malgas in S versus Vilakazi. And what it really tells you, in short, and you've heard it so many times, my lady, and I'm sorry to repeat that. It says that, and I go to page 3 of Malgas. The first one that's important is paragraph 9, where the Supreme Court of Appeal said the following: I can see no warrant for deducing that a legislature intended the court to exclude from consideration ante omnia, as it were, any or all of the many factors traditionally and rightly taken into account by courts when sentencing offenders. So it's not that you must now suddenly show something new, something extraordinary, something special, something exceptional. It's not true. And it is so well put in paragraph 22 of the Malgas case. And that only a court can understand, because a court is trained in law and in experience to understand that feeling that you get. When you look at the facts, you get that distinct feeling, this is more or less where I should go. And it tells us what that feeling is. It says, the greater the sense of unease a court feels about the imposition of a prescribed sentence, the greater its anxiety will be that it may be perpetrating an injustice. Once a court reaches the point where unease is hardened into a conviction that an injustice will be done, that can only be because it is satisfied that the circumstances of the particular case render the prescribed sentence unjust, or, as some might prefer to put it, disproportionate to the crime, the criminal and the legitimate needs of society. And I submit that there must be an unease when anyone tells you must send Mr. Pistorius 15 years to jail, where it's a man that was on his stump 3 o'clock in the morning who did not want to kill his girlfriend, who believed, and I will show you later, that this finding by the court is undisturbed, who believed that she was at the time in the bedroom. That's undisturbed. Do you send that person 15 years to jail? How is that so far removed from Vleisversagie case? How is it? There are differences, but is it so far removed that the one should not be prosecuted and the other one must be sentenced to 15 years? We submit that unease and that anxiety must be overwhelming in this case. And that only would indicate one thing: it cannot be. It cannot be, provided, and this court has done it, provided that you prepare to entertain the correct facts and not to be drowned by the many perceptions, provided that. Because if you allow yourself to be drowned by perceptions, by wrong facts, any sentence will do. The same was then said, I refer to Vilakazi, and I've underlined in paragraph 15 on page 4 that one part where it says, with reference to Malgas, that the provisions of the Act vest the sentencing court with the power, indeed, the obligation to consider whether particular circumstances of the case required a different sentence to be imposed. And a different sentence must be imposed where the court is satisfied that substantial and compelling circumstances exist which justify it. I'm not going to read all of it. It is there on page 5, my lady. I will then go and ask you to go to paragraph 6 of the heads of argument. Page 6, my lady, I'm sorry. It says the SCA judgment. And we say to you, my lady, that when, for the purpose of this case, when considering, just the abbreviation, the Supreme Court of Appeal, it's no disrespect. I have huge respect for the Supreme Court of Appeal, of course. When considering the SCA judgment in relation to the present sentencing proceedings, it must be borne in mind that the SCA did not reconsider the merits of the case, but considered questions of law relevant to dolus eventualis and error in objecto. As such, we say to you, my lady, that the legal and factual basis upon which this honourable court relied for the imposition of sentence remain valid unless different findings apply as a result of the SCA judgment, and then only to that extent. We submit, my lady, that it's in this context that the SCA judgment must be considered and applied to the undisturbed factual findings and sentence considerations made and applied by the trial court. What we then do, my lady, we then proceed to the SCA findings. So we first isolate them, and you will then see a later process where we combine them and say, well, let's look at the trial court's finding and to the SCA finding and to see what the position is. Paragraph 13. The SCA found that in discharging the shots, the accused acted with dolus eventualis. And let's immediately say, not dolus directus. There is nothing in the SCA judgment saying there was an argument, saying that she ran to the cubicle, saying that he wanted to shoot her. That's not this court's case, and it's not the case in the SCA. It is a very different case. And before I read to it, in short, it is this. when he fired the shots, this court was of the view that he was genuinely in fear of his life. And the fact that he did not fire chest high but lower had this court in a position where the court had to consider, would this now be culpable homicide or dolus eventualis? And the court very carefully considered the two and ultimately came to the decision, because of the subjectivity of the mind, that it was culpable homicide. But when it came to sentence, the court made it plain and clear that, and it explained to us that process that the court must have gone through, that whatever I found, it bordered on dolus eventualis. So we're really talking here on a difference in view whether it bordered or whether it was. And that's all. So the SCA found then, we say in paragraph 13, the SCA found that the trial court had concluded that dolus eventualis had not been proved premised upon an acceptance that, as he had thought Riva was in the bedroom, he did not foresee that she was the person in the toilet. Simply put, the finding was that the accused did not realize that it was Riva in the toilet. He did not foresee that his action in shooting could cause her death, and he could not be held guilty of her murder. The SCA found that the above finding went to the heart of the first question of law reserved, i.e. whether the principles of dolus eventualis, including so-called error in objecto, were properly applied. And the SCA found then in this regard, what was an issue therefore, and this is so important, was not whether the accused had foreseen that Riva might be in the cubicle when he fired the fatal shots at the toilet door, but whether there was a person behind the door who might possibly be killed by his actions. This is so important. We will show you later. You're finding that he genuinely believed at the time of firing of the shots that Riva, the deceased, no disrespect, absolute only respect when I refer to her, was in the bedroom is undisturbed, not reconsidered. So how, when I look at Vleis Versace, when he thought it was a thief driving away in his car, he also had a mistaken identity. The mistaken identity is not wrong. It's not taken away from the accused. It is a legal principle to say it does not help you in law because you still fired at a person, notwithstanding the fact that you genuinely believed that the deceased Riva was in a bedroom. But what do we have now? We get this impression that the SCA judgment is now that he wanted to kill the deceased, that he did not believe that she was in the bedroom at the time of the firing, that he did not believe it's an intruder. That's not right, my lady. It is so wrong. That is not the finding of the Supreme Court of Appeal, and it was not the purpose of the appeal before. They made it clear that they're not there to reconsider your factual findings. It was on that one aspect, and I'll come to that where they then deal with it. In 13.3, the SCA further found in this regard, what was an issue therefore was not whether the accused had foreseen that Riva might be in the cubicle when he fired the fatal shots at the toilet door, but whether there was a person behind the door who might possibly be killed by his actions. The accused incorrect appreciation, that is so important. It's there. The accused incorrect appreciation as to who was in the cubicle is not determinative of whether he had the requisite criminal intent. There is his incorrect appreciation. It's not rejected. What was his incorrect appreciation? His incorrect appreciation was twofold. One, that the deceased was in the bedroom at the time, and two, that an intruder was in the cubicle or toilet. That was his incorrect appreciation, but in law it did not help him. It goes on. Consequently, by confining its assessment of dolus eventualis to whether the accused had foreseen that it was Riva behind the door, the trial court misdirected itself as to the appropriate legal issue. Then paragraph 13.4, the SCA further found that the trial court's finding that if the accused had intended to kill whoever was behind the door, he would have aimed higher than he did. did not assist the accused, as it was inevitable that a shot fired through the door would almost certainly have struck the person behind it. Vleis Versace. When you fire at the car when a person driving it, likewise, inevitable, that would almost certainly strike the person. Consequently, that's paragraph 13.5, the SCA found, in these circumstances, I have no doubt that in firing the fatal shots, the accused must have foreseen and therefore did foresee that whoever was behind the toilet door might die, but reconciled himself to that event and gambled with that person's life, not Riva's life, that person's life. This constitutes dolus eventualis on his part, and the identity of his victim is irrelevant to his guilt. Then, as to the defence of putative private defence, the SCA found that the defence of putative private defence implied rational but mistaken thought that even if the accused believed that there was someone else in the toilet, his expressed fear that such person was a danger to his life was not the product of any rational thought. So what the Supreme Court of Appeal says, and we'll deal with later, he says, although frightened, I just don't, your fear that you thought that you could fire the shots was not rational. And I'll come back to that, how you should approach this in sentence, where the case law tells you, when you deal with sentence, then you become far more subjective. And then you look at a person's subjective mind. And we will deal with that when we deal with his vulnerability. And further, although he may have been anxious, it is inconceivable that the rational person could have believed he was entitled to fire at this person with a heavy caliber firearm without taking even the most elementary precaution of firing a warning shot. And that was the criticism, says, you should not have fired. You should. But that does not mean that he did not believe that Riva, the deceased, was in the bedroom. That does not mean that he did not believe it was an intruder. It is just that it was not rational and therefore not genuine to believe that he was entitled to fire the shots. That's it. No more, no less. The SCA found that this constituted prima facie proof that the accused did not entertain an honest and genuine belief that he was acting lawfully. Interesting words. As such, the SCA found that although the accused may have been anxious and although the accused was frightened, most certainly no one's going to say that he was frightened of Riva, the deceased. For the person still not wanting to believe this, are they saying that he was frightened that she attacked him? What would the thought process be? There cannot be such a thought process. Who was he frightened of? The deceased or an intruder? It's only one person. It's 3 o'clock in the morning in the dark. There's only one person that you could be frightened of, or perceived person, an intruder, not your own girlfriend. So I read again. As such, the SCA found that although the accused may have been anxious and although the accused was frightened, the accused fired without having a rational or genuine fear that his life was in danger and the shooting was lawful. Mr. Versace, firing the shot. He could not have a rational fear that he was entitled to shoot and that his life was in danger. The person was driving out. The person was driving out, but there we have the sympathy from some part of the public. There we have the sympathy. He made a mistake, but not Mr. Pistorius. No, I will come back because of all the wrong evidence and the refusal to accept a proper analysis of the evidence, to show the impossibility and the unreliability of that evidence, they stick to it. We say then, and then the court found, obviously, the Supreme Court of Appeal, that the defence of putative private defence could not be sustained. And then it follows that there must be a conviction not of dolus directus, but dolus eventualis. We respectfully submit, my lady, that what we then do, we say it's necessary to reconcile the findings of the trial court in judgment and in sentence with the above findings of the Supreme Court of Appeal in order to consider a just sentence. Factors which arose subsequent to the original sentence must also be considered, and then that proposed sentence must be blended by the well-known concept in court, and that is concept in imposing sentences, and that is the concept of mercy. We deal with moral blameworthiness, and may we make this submission. Once you have reduced moral blameworthiness, I cannot think that any court would say you qualify for the minimum prescribed or discretionary sentence. Because factually, it's wonderful that you have remorse, and it's wonderful that you have 5 children to look after, and that you go to church every day, and that you donate money for charity. They're additional smaller factors. What is really important in a case? You look at that person's moral blameworthiness to determine who is it that I'm dealing with. You get this person, he rapes a 3-year-old little girl, and you ask him why, and he doesn't want to explain to you, or he doesn't give you a reason, or he just did it because he wanted to do it. You understand the moral blameworthiness and the total absence of a reduced moral blameworthiness. And you compare that with a person that's 1.5 meters high, 3 o'clock in the morning in the darkness, and he thought, incorrectly, that he's firing shots at an intruder. And you say, can you mention it in the same breath? And you immediately realize that per se, we're dealing with a reduced moral blameworthiness, and per se we get that when we deal with dolus eventualis, because dolus eventualis only means one thing. I did not really have the direct intention to kill that person. Not that evil intent, not that murderous intent. It is rather what you foresaw and you reconciled this. It's a further step down. It's softer, with a harsher result. But the moral blameworthiness is softer, my lady. We refer you to the case, we say, when considering the moral blameworthiness of the accused for purposes of sentence, a court must look solely at what an accused believes, because we're dealing with sentence now, my lady, not the conviction, and intended when deciding whether he had reduced moral blameworthiness. We refer to Ferreira and others where it says the criterion for determining moral blameworthiness, it is said, is subjective. This means that one must look solely at what an accused believed and intended when deciding for purposes of sentence whether moral blameworthiness has been reduced. Substantial and compelling circumstances would seem self-evidently to reduce it. It seems to me that the true question to be answered is whether the threat from which each sought to escape was still subjectively perceived to be real and present danger, albeit, and it's so important, not imminent enough to escape criminal liability altogether. This could have been the Pistorius case. At the time of the offence, I say so, and then it goes on to the facts, which are not too important. That's the Mate case, and also Trajan's. Now, what we do, we say, now let's shift the focus to the trial court's finding, and it's no disrespect when I refer to this court as the trial court.
Well, it is the trial court.
Yes, it is, but
Yes.
I mean, I should every time say the honourable trial court, but it's just for purposes of short sentences. So would you please read in, I say it softly every time, my lady. The trial court accepted, and we've got the judgment here. The trial court accepted that at 3 o'clock, the accused heard a noise, which sounded to him like the bathroom window opening. He believed an intruder had entered a house through the bathroom window. The trial court found, and I quote, the bathroom window was indeed open, so it was not his imagination at work when he thought he heard the window slide open. He armed himself with a loaded firearm and went to the direction of the noise. I still quote, he heard the door slam shut. The toilet door was indeed shut when he fired 4 shots at it after he heard movement inside the toilet. Now the important part, my lady, with respect. These findings remain undisturbed by the Supreme Court of Appeal. It was not the duty of the Supreme Court of Appeal in a question of law to reconsider your facts. It did not. These findings remain undisturbed. The accused approached the bathroom in the belief that an intruder had entered his house. He did so, and that was his evidence to protect himself and the deceased. That protection that he wanted to protect the deceased, that's now gone. He's now a villain. because the perception is the Supreme Court of Appeal said he murdered the deceased, without saying what are the true facts. I say again, the Supreme Court of Appeal did not, correctly so, not reconsider this finding. 2, the trial court found that when proceeding to the bathroom and at the time of the shooting, the accused believed that the deceased was in the bedroom. The Supreme Court of Appeal did not reconsider the trial court's finding at the time of the shooting that the accused believed that the person in the toilet was an intruder and that the deceased was in the bedroom. The fact that the accused is criminally liable on account of dolus eventualis and by applying the principle of error in objecto does not mean that the accused foresaw that it was the deceased in the cubicle and that he reconciled himself with that. That is clear. I've dealt with that. It was pointed out. The accused's actions remain goal-directed to protect himself and the deceased, and the fact that his actions did not meet the legal criteria for the defense of putative self-defense does not mean that his subjective state of mind was not that it was an intruder in the toilet and not the deceased. That remains. As was stated in Ferreira, the true question to be answered is whether the threat was still subjectively perceived to be real and present danger, albeit not imminent enough to escape criminal liability. The accused believed that it was not the deceased in the toilet but an intruder also does not defy logic. I say this we say this by the by. It's not that you come and tell me something that is so absolute nonsense, so illogical that it does not make sense. And we say, who else other than an intruder would have entered the house at 3 o'clock? In your mind, when you hear that noise in the bathroom and you believe that it's not the deceased, who else would enter 3 o'clock? Someone coming to clean the house? Someone coming to buy the house? Or who? We know where we live. We're fearful. A logic thought process would be an intruder. Furthermore, we say, my lady, his belief that it was an intruder in the toilet was supported by his actions when he realized that it was the deceased in the toilet. This was further confirmed by his actions thereafter when he frantically took all possible steps to try and save the deceased's life. The trial court found that the seemingly incongruous conduct of the accused to go to the bathroom instead of taking evasive action, if I may say, my lady, with respect, the trial court was in this privileged position to see, to hear, to feel, and analyze every bit of evidence. And the court found it was explained by Professor Derman as a fight as opposed to a flight response. The trial court correctly rejected that as a defense. Correctly so. We didn't appeal it because we thought it was correct. But that does not mean that it doesn't explain his actions. The trial court accepts that the accused, that's the finding of the court. So let me read it correctly. This court accepts that the accused is a fight rather than a flight reaction person, as Professor Derman testified. We say that the SCA, the Supreme Court of Appeal, did not reconsider this finding, and the finding remains. Without balance, of course, then we know the second expert, Professor Simon, absolute expert, said, if the shot's there, and you look at the fatality of the wounding, it was not possible for the deceased to have screamed. It could not be. That's confirmed by Dr. Stipp. That's confirmed by Professor Botha. But now you have witnesses who heard a woman screaming, and the court said they're unreliable. They're unreliable for many reasons. But inter alia, they're absolutely against the objective facts, against the experts. They're against a timeline. We could, within 30 seconds, determine when the shots were and when the cricket bat, because we had the times when people say, I've just heard shots. And you could see the time of the call. But somehow, people would refuse to entertain it and say, she was screaming and running away, knowing it's impossible on the objective facts. It remains and is punished forever and ever. Then we say where the court explained the correct sequence of the event, the trial court, the SCA did not reconsider the findings. It was not its duty to do so. And then I've already done it when I referred you to the factual position of the telephone calls, the screaming, and by the way, the direct neighbour saying, well, there's Oscar screaming. That's all gone. They don't want to hear it. It doesn't accord with your perception that you want to follow. 17.6, bottom of page 15, my lady. The trial court found that in its totality, the evidence failed to establish that the accused had direct intention to kill the deceased. I wish I can read it 10 times, but I would not do so, my lady. And then we say, dolus directus, and because dolus directus is, I wanted to kill the deceased. That's rejected on objective facts, not on maybe you did, maybe you did not. We know the facts, we know the timelines, we know the evidence, the expert evidence. We say dolus directus remains rejected by the SCA, both with regard to the deceased and the perceived intruder.